Excellencies, distinguished guests, please take your seat. Now.
Excellencies, not turn on yet. Hello, okay. Excellencies, distinguished participants, ladies and gentlemen, good morning. It is my pleasure to open the proceedings today on Thai politics and the role of a so-called independent institution, including the Constitutional Court, Election Commission, National Anti-Corruption Commission, National Human Rights Commission, among others. These institutions are rooted in political reform movement in the mid-1990s and culminated with the popular watershed 1997 Charter. While these institutions were designed to promote the checks and balance environment with greater transparency and accountability of Thailand political system, as well as political stability and effectiveness of government, they have become politicized over the past 2 decades. Initially, these institutions were politicized under the era of former Prime Minister Thaksin Shinawatra, who formed the Thai Rak Thai Party in 1998 and won a resounding election in January 2001. At that time, Thaksin had issues with the concealment of his assets under the drivers, maids, and gardeners' names. Eventually, the Constitutional Court ruled 8-7 that Thaksin was not at fault. 4 of the 8 judges said he did not know that his assets were under other people's name. And the other 4 said the court did not have jurisdiction. That period, more than 2 decades ago, began the politicization process of this independent institution. The political roles of this institution then went the other way, from being pro-Thaksin to being anti-Thaksin. In fact, partly because of the anti-Thaksin years were longer, this institution appeared to be more politically different in the later period. For example, partly as a result of 2 military coups in 2006 and 2014, the Constitutional Court has dissolved 2 major Thaksin-allied political parties in May 2007 and December 2008, disqualifying a sitting Prime Minister along the way for having hosted a cooking show. After the March 2019 election, the Constitutional Court ruled that it had no jurisdiction when the cabinet swore in the incomplete oath, and later that a cabinet minister could continue in office because his drug conviction and jail terms occur in Australia, not in Thai soil. In February 2020, the same court dissolved yet another major political party, this time Future Forward Party, because it had borrowed funds from its leader, who was also disqualified and banned from politics for 10 years because he held shares in a media company, a practice which seemed common among a host of other elected politicians. On the other hand, the Election Commission became active in its own decision that somehow helped small parties and enabled the ruling Palang Pracharat Party to take power. The Anti-Corruption Agency, meanwhile, took a deputy prime minister at his word for owning luxury watches that allegedly belonged to a deceased friend. The list go on, but it is clear that this politicization of this agency has weakened Thailand's democratic institutions, such as political parties. What to do and when and how to adjust, reform these institutions are our focus this morning. We need these institutions to serve as a checks and balance mechanism and fair accountability, promoting roles and functions they were originally set out to perform. Let me thank to our speaker, Ajahn Dr. Kem Thong, lecturer from our Faculty of Political Science here from Department of Government, Mr. Ying Cheep Achanont, Program Manager of the iLaw, or the Internet Law Reform Dialogues, and Mrs. Angkana Nilaphajit, former National Human Rights Commission, and Ajahn Dr. Jade Thunavanik, Chairman, Faculty of Law, College of Asian Scholars, and a former constitutional drafter. So let me return the floor to Ajahn Thitinan. Thank you very much.
Thank you very much. Look, I want to also thank the speakers again for joining us today, sparing your time. I also want to welcome our audience here in person, also our audience members online. We also have this event live streamed online. My name is Thitinan Pongsuthirarak. I'm the director of ISIS. Let me proceed this way. Look, I think our topic today is the independent institutions, why and how they might be reformed. I think that at this stage it is beyond doubt that these independent, so-called independent institutions are in need of change, reform, adjustment. I don't think that anyone disputes that anymore, right? Now, these institutions were designed, as the Dean Professor Ek said, to provide checks and balance mechanisms and to promote transparency and accountability of the political system, also the stability and effectiveness of the government of the day, and it was all from the 1990s. But over the last 2 decades, and if our audience members are interested, and we all are in Thai politics, if you look at Thai politics, something is not right about Thai politics. It's very crooked. And along the way, we've seen, as Professor Ek mentioned, from 2 decades ago, a prime minister at that time had assets and wealth, hidden concealed under the names of the gardener and the driver and the cook, and then he was acquitted by the Constitutional Court, even though it was very blatant. But then along the way, his opponents have also used these institutions for their own political aims and motives, including dissolving the ruling political parties in 2007, Thai Rak Thai Party in December 2008, Palang Prachachon, People's Power Party of Thaksin Shinawatra. And then after that, more manipulation. I mean, along the way, as Professor Ek mentioned, Prime Minister Samak was disqualified because he hosted a cooking show, right? That's a world-famous disqualification. Later on, another constitution came in place, and we have, the cabinet in 2019 swore an incomplete oath, but yet got away with it. And Prime Minister Prayut, of course, did not declare his assets. He doesn't have to. It was ruled. We had a cabinet member who was convicted and jailed in Australia for a drug offense. But then, of course, the Constitutional Court said it happened in Australia, and therefore he can continue as cabinet member. We have a bunch of other cases that I don't want to take too much time to go into, because we will be hearing about them from our speakers today. I want to start with Ajahn Kem Tong, and we have a number of these institutions based on the design of the 1997 Constitution, not just the Constitutional Court, but also the Election Commission, which has worked in conjunction, in cooperation, apparently, it seems, with the government of General Prayut, and also the National Anti-Corruption Commission, right? This is designed to catch corruption and prevent corrupt people, unscrupulous people from being in politics. But then the case of the watches, we had as you all know, world-famous event. The Deputy Prime Minister wears luxury watches and then said it belonged to his deceased friend. And then the court said, the Anti-Corruption Commission said, well, of course, that is true. But there are also other institutions, the Human Rights Commission, the Auditor General, the Ombudsman, and so on. So I'm going to start with a law expert, the political science faculty, gained from the law faculty, because Dr. Kem Tong was actually a lecturer in the law faculty, but he moved to our faculty. So we had a big gain, but we lost one to his faculty too. So there was a kind of a swap, but I think we had a net gain. Anyway, we will start with Ajahn Kem Tong, and then we'll move down to Kun Ying Cheep, Kun Angkana, Ajahn Jade. Ajahn Kem Tong, you've written a lot about the Constitution, these independent institutions. Can we trace this back, the kind of the constitutional legal manipulation back to April 2006 with the judicialization of Thai politics? For those who are recent to the Thai political scene, back in the early 2000s, we had a lot of topsy-turvy, Thaksin, anti-Thaksin, and it ended up in 2006 when we had a one-party election, and the Thai monarch at that time encouraged the judges, Constitutional Court judges, and also the Administrative Court judges, to find a way out of the Thai political crisis. Since then, there has been a marked, very salient judicial activism and assertiveness and interventionism. So, Ajahn Kem Tong, is this where, if we look back and we say, okay, when did this all start? And then, what do we do about it down the road? If we're going to get Thai politics right, we would have to reform these institutions. So, Ajahn Kem Tong, please share with us your expertise and your work. Thank you.
Thank you very much, Ajahn Thitinan. So, how many minutes do I have?
15 minutes, 10 to 15.
Most. All right. Okay. Thank you very much. I'm glad to be on this forum because when we come to the Thai politics, I think the most popularly discussed topic is often electoral system. So whenever we talk about constitution, the topic tends to go to that direction. We talk about the new parliament, the new Senate. 2 years ago, when there's a lot of proposals of a new constitutional amendments submitted to the parliament and proposed to the public, most of them are also about having a better, a fairer electoral politics. And I think one only I-law draft and another one afterward that address the very issue of independent agency. So the topic has been neglected for a very, very long time. But I would argue that, so Ajahn Thitinan mentioned April 2006, but actually the seed of our problem goes back beyond that date. I mean, to the drafting of 1997. Actually, independent institution is the most long-lasting legacy of 1997 Constitution. So the dream about right and liberties, the dream about strong electoral government, all gone with 2 coups. I mean, it couldn't withstand the last coup. Obviously, the 2017 Constitution has very little of what we call constitutional afterlife. The ghost of 1997 Constitution isn't there anymore. But the independent agencies are still there. So let's go back to the day of the drafting of the 1997, the People's Constitution, and actually people tend to remember that it's all about having a strong government, a strong political leadership, but actually it's about having a strong political leadership under a very strong control and scrutiny. And it's come down to one factor, that is we have very weak electoral politics back then. So there's a huge distrust among drafters about all these incoming politicians. And this is not unique to Thailand. By 1980s, 1990s, with the third wave of democracy and people are drafting new constitution for all these new democracies, one thing that we realize is that these countries, including Thailand, has very thin definition of democracy. We have election, we have government by election. These elections are often very not free, not very free. In many countries, politicians would propose very illiberal policies, suppressing opposition, ignoring human rights. So there's a need. They say that this is a democracy without a real spirit of democracy. So you can't leave politics in the hand of politicians in the parliament. So they propose having a guardian of the system, and that's where all these new institutions come in. So we upgrade some of our existing bodies. The NACC, the National Anti-Corruption, has been upgraded into independent one. The Auditor General has been upgraded, but also we introduced Ombudsman, we introduced Administrative Court, Election Commission, and Constitutional Court. So weak politics can be both cause and effect of this phenomenon of judicialization of politics. It's a weak electoral politics that stimulate drafters to introduce all these new agencies. But also as the problem drags on, that we have too independent, too powerful institutions, parliamentary politics tend to get weaker and weaker. For example, last year in January, the parliament is considering the constitutional amendment, not yet in the third motion yet. But some of Palang Pracharat MPs submit a complaint to the Constitutional Court, and the Constitutional Court stepped in and said that the amendment is unconstitutional, and the motion collapsed. And that shows that even within the Parliament, some MPs are very willing to bring the courts in, to bring Election Commission in as a political tool to sabotage their colleagues, and that tend to make electoral politics look worse and worse, actually. But that's part of it. So 1997 introduced independent agencies, and I think no one argued that at a certain point you need a certain level of independence for these agencies. I mean, in any country you would need an independent investigative body for human rights violation, an independent investigative body for corruption investigation, and you need some independent agency to organize an election. You cannot leave it to bodies under the direct control of Prime Minister. They would be subject to manipulation, to intervention. They couldn't work. So there need to be some independence for this agency, but to which level, how much is too much independence? And here, the drafter conflate a few concepts here. They conflate independence with neutrality, with accountability, non-partisanship, and apolitical. So you can so independence for the 1997 drafters simply come down to become a non-partisan body. But of course, these non-partisan bodies can be very, very political, because just turning all these political disputes into the legal procedures doesn't mean that it becomes less political, right? So you throw political question to the Constitutional Court. It is still very, very political question, although the court will try to solve it through a legal means. So these institutions might be non-partisan in the sense that the Constitution require none of these commissioners to be a member of political party, but still they have political ideologies. They side with certain camps, and this is gonna get worse when the Thai society become more polarized. They would choose, and this is where the big problem is, because political dispute in Thailand is not about a fight between or among parties. Right now is a fight between two ideologies of democracy and anti-democracy. So of course you can have a non-partisan constitutional court judge who is very political and side with an anti-democratic ideal. And how are you going to do with that? So letting them to be very independent might not be a good idea, actually. And to conflate the idea of independence with being professional is also a big mistake. You can have a very independent, non-professional commissioner too, right? If you let someone to do that job without accountability, they are not going to do it very professionally. In the end, they're going to be like, whatever, I'm going to do whatever I like, and that's so there's a few conceptual confusion among drafters. I don't think this gets fixed at all. Two constitutions later, they become more and more independent instead of more accountable. So accountability is my last point for this round. These independent agencies are not under a principal-agent relationship, which means that the government is their principal and the government is an agent of the people as the principal. So there's no direct chain of accountability, command and control from the people to these independent agencies. The relationship is more like a delegation. So once you delegate the job to independent agencies, they're on their own, and there are very few control or intervention after that. So this is basically what the judiciary has. Their model of accountability is to be self-disciplined. As a judge in the court of justice, if they commit some error, is the panel, is their own colleagues that are gonna correct them. But this model works less well with these agencies. There's only 5 election commissioners, and they know each other, and no way that the 4 other commissioners gonna discipline their colleagues. It's not unlike in the court where you have appeal court and the Supreme Court. So there's layers of colleagues. So the more superior one can step in and correct the junior colleagues when they make mistakes. That's not gonna happen in the Constitutional Court where there's only 9 judges and they know each other from King Prachadipok's cause or WPO cause. There's a lot of these special networking causes, and they know each other for 10 years before they get nominated. So the drafter tend to emphasize heavily on pre-nomination vetting process. They have to be an expert in law, they have to be an expert in political science, they have to be scrutinized by the Senate. All fail. I mean, there's post-nomination scrutiny. such as that they can be impeached or they can be investigated by National Corruption Commission or impeached by the parliament. But when electoral politics become very weak, there's no general will to impose all these sanctions. And with, you can say a certain level of cronyism among these independent agencies, post-nomination doesn't work. So we rely heavily on pre-nomination. But this pre-nomination process, if you follow them closely in Thai politics, they're not transparent at all. We don't know what they discuss when the senators invite the nominee to แสดงวิสัยทัศน์ to show their vision. These transcripts are very difficult to get access to, and we don't know what they discuss. Maybe there's no discussion at all. We never know, especially acute for these current institutions. So that's my 3 points now. Wrong concept, wrong idea, wrong design. And you asked me for a solution. I'm going to wrap up here. So clearer conceptualization is needed, not to conflate independence with all the rest of the qualities. So we have to rethink about what independence means. We have a lot of independent agencies within the administrative branch that is still subject to the review from administrative court. For example, the Bank of Thailand is an independent agency. Chulalongkorn University is an independent agency to a certain extent. I mean, there's a level between the minister or prime minister to all these bodies, or the Security Exchange of Thailand Commission. These are independent too, but not at the constitutional level. So they're still subject to judicial review. Maybe we need that. And maybe we need to rethink about pre-nomination accountability mechanism. So all these wettings fail to prevent ill-qualified persons to assume the post. So maybe, as I mentioned before, transparency is the key. It has to be like Chat is doing. It has to be a live stream online. Everyone can watch all the Q&A between the senators and all these nominees. So we know who are they. What are they thinking? What conflict of interest they may have? And that is what I would suggest for this round. Thank you very much.
Okay, thank you, Ajahn Kim Thong. Do you think we need to write a whole new constitution to make that happen? Let me first just tease out a few points that you talked about, that you discussed, you brought up. The notion of legal independence is one thing, but there's another concept, kind of the functional autonomy, right? So you can be autonomous without being independent, and I think that's something that we have missed in these institutions. I want to tell our audience members that we're actually talking about not just today's discussion is really about the last 3 decades of Thai politics. This goes back to 1992, which goes back to 1991. We had a military coup. And in 1992, we had a big crisis, protests and violence and so on. And there was a realization at that time that Thailand needs to get out of this trap of so-called money politics, right? Money politics. And the money politics, basically, you have these politicians buying their way into power and then recouping their investment with a lot of profit, a lot of corruption, a lot of graft. And then this becomes, cycle, and then the military intervenes because of the corruption, and then we end up in the same with the vicious cycle of elected government, corruption, military intervention, new constitution, and election again. So this vicious cycle, there was a realization at that time, Ajahn Kim Thong, that we have to have a new constitution in order to get out of this vicious cycle. And it looked good for a while. I think the one key institution, Ajahn Kim Thong, was the elected Senate at that time, because all these institutions, all these, the Election Commission, the Constitutional Court, Human Rights Commission, Anti-Corruption, and so on, they were kind of nominated, selected through the elected Senate, which at that time was seen as impartial, right? Impartial. So along the way, in the last 3 decades, Thai politics has ended up in the same place. the money politics, and the constitution is not addressing it. So I'm just wondering, Ajahn Kem Tong, if you just a very quick 1 minute response. So do we need to write a whole new constitution?
Of course, certainly. I mean, there's something that we can fix, like we can amend a certain, like tweak the existing provision. But overall, I mean, and it relates to electoral politics too. As long as we have this kind of electoral system, we have this kind of Senate and MPs, Thai electoral politics remain a quagmire, and people don't have much public trust. They would, I mean, naturally they tend to go to these independent institution. So the whole like overhauling of the charter is needed, definitely. Okay.
Yeah, you mentioned electoral politics. I'm going to move to Kun Ying Cheep. Electoral politics, and what I think Ajahn Kem Tong meant is that the weakness of political parties, right? And how parties come and go. There's something different this time. I think, we have a party that was dissolved, and I'm talking about Future Forward Party, and the successor party, the Move Forward, is still pretty, it's still pretty strong. And then the Pheu Thai is the third vehicle of two dissolutions of the earlier parties, and Pheu Thai is still around. So electoral politics maybe it could I think it's strengthening a little bit, at least because parties are lasting longer. They don't just come and go. Kun Ying Cheep, I mean, you see a lot of in your role and capacity in your in I-Law. What's your outlook? I mean, how do we come up with the institutional design in the Constitution so that we can, have a more effective government and more accountable political system?
Actually, we have successfully proposed two drafts of the constitutional amendment to the Parliament. The first draft on 2020. At that time, we proposed just to get out of this current system. We don't exactly propose the new process, how to select people into independent institutions. Honestly, because I don't know how to, and I don't think I have legitimacy or authorities to draft the new process by myself. So the most highlighted proposal, the first most highlighted proposal is to rewrite the whole new constitution by the elected council that will come after this. But the first proposal was dropped. And the second proposal last year, called resolution proposal, also proposed a new model on how to select these people into the independent institutions. Actually, Ajahn Piyabut and Kun Aitim Palit initiate these ideas. They propose that we can have someone from the judiciary institutions, but we propose to have 6 names from the government MPs and 6 names from the opposition parties, and the Parliament will together vote for the top 3 rank from each 6, and anyone who can pass this process also need 2/3 of the majority of MPs to sit in the independent institutions. That means any people who pass this process should be quite neutral or acceptable by both sides of the MPs in the Parliament. This is just the new model that already proposed to the Parliament and dropped it on November last year with only 3 votes from the senators. So we have already proposed at least twice, but we also I want to answer your question that point to Ajahn Kem Tong that we also need to rewrite the whole new constitution soon to find a better system that we can live together in the country. Can I also have my pictures? I have some pictures to show. The first one, thank you. It feels quite strange living in the country under this kind of structure, under the current constitution, where all 6 independent institutions are selected by the process of the NCPO. At the first 5 years, NCPO selected people to be National Legislative Assembly, and the NLA selected people into independent bodies. But the last 3 years, the NCPO selected senators, and senators also selected people into these independent bodies. Sadly but true, 90% of Thai people, I think 90% or more of Thai people don't understand this process. When we discuss about the problem under this constitution, people will focus more on the hand-picked senator who has power to vote for General Prayut to become Prime Minister. This is the most obvious and most easy topic that we can discuss about constitutional problems. So people are more difficult when we talk about these 3 or 2 layers of problems. So I agree with Ajahn Kem Thong that we are delighted to talk about this issue today because it is ignored for a while. And I think 95% of people don't know that when there are this kind of process, the NLA and the senators not just being rubber stamped to approve people in the positions, but they carefully selected people that they trust. For example, the election commissioners, the current 7 commissioners, are selected 3 times. They pick someone they like, and they eradicate some names they don't like. For example, for human rights commissioners, they selected 4 times, right? And they spent like 3 years selected 4 lists of names that they already think, okay, these people are maybe the one that they want to be in positions. And 98%, I think 98% of people don't know that all these processes are declared to be secret. The meeting minutes and the votes we cannot access. The senators and the NLA members also vote to do this behind closed door. I many times challenge this process by submit a letter to access to information, and we have some information in papers but sealed with another paper on the cover, so we cannot access on why they select someone and why they not select someone. Even though when I joined protests demanding to change this current regime, most of people don't have these diagrams in their mind. When I talk about this issue, I can sense that some eyes are blank, they don't understand. So it is sad but true that Thai people are not really aware of this structure. It sounds a bit okay for someone who are okay with the coup d'etat to have some temporary organization to select people to be commissioners in these institutions for a while, for some time. But because they are in power for too long, for 8 years, so we have the next picture, please. So we have this as a result of the long-run military government. These are the commissioners who are in position today. The green represents people who are selected by the NLA, and the yellow represent people who are selected by the senators. So they took control of all institutions. The red sounds a bit okay because they are in position, they were approved before the coup, so they are approved not by the NLA or senators. But no, because the red will finish their term soon, next year. That means they will be selected again by these senators. The green sounds actually better because they will finish their terms maybe in the next 2 years after these selected senators finish their terms. So actually the red are more scary because they will be select another person into these positions by the selected senator and will stay longer for the next maybe 9 years before we can get out of this situation, this structure. Okay, I'll finish here.
Thank you very much, Kun Yingshi. But that's a very clear picture. So we're still living with the coup, the military coup period, right? And the legacy of the coup could last 2 decades, up to almost 20 years from all these appointments, which lead to more appointments. I'm also glad that you mentioned the 6. So we're talking about the main 6 agencies: the Constitutional Court, the Election Commission, the National Anti-Corruption Commission, Ombudsman, Human Rights Commission, and the State Audit. So these are the 6 main ones that are at issue, and then they were appointed first by the military junta through the NLA, and then after that it's now through the Senate, which is was appointed by the military junta. So the Senate, คุณยิ่งชีพอาจารย์เข็มทองด้วย initially the Senate was fully elected, right? 1997 Constitution. We've had 3 constitutions in the last 25 years, and then gradually the Senate became fully appointed by the military, more or less. So that's the key institution, I think. That's the key institution, the Senate, because it does all these appointments, and basically the structure of the Constitution, and therefore the structure of Thai politics, is still very much under a military coup legacy and regime. Kun Yingcheep, it's a quick question. So if we're going to rewrite these rules wholesale, the whole comprehensive, to start over again, would it be best through, doing the amendments, probably not a good way, right? Because you have to have a lot of amendments. Would the mechanism be best through the Constitution Drafting Assembly, the CDA, like we had in the mid-1990s? I hate to say that you have to go back to that again, because it means that we're not going anywhere, right? We're starting from scratch again. But would the CDA be a good way forward?
It is actually only our only role model that we can think of, because we have seen it in our history. But we also open for another options. But the only principle we have to insist is this process must be from people participation, not just by some single command or some group of people who are from some kind of power.
So that's another big challenge. If we have a CDA, how many people should be in this assembly, drafting assembly, to write a new constitution? How many? We had the one in 1997 constitution, we had 99 drafters. 99 people in Thailand writing the constitution for the whole country, right? And if I remember correctly, 1 from each province and 23 experts. Now, if you think about your countries, how you get a constitution, if you have constitutions, who write them? And for us, it was the 99 and the 23 experts. The experts ended up with more influence, and the experts are drawn from, universities, and so I think there was supposed to be some political scientists, a lot of law experts, and so on, and then the provinces, provincial representatives. Now the CDA, if we have another CDA, what would be the modality of representation? Kun Yingcheep, do you think it should be like this 1 per province? How do you get the representativeness for the whole country, and also the expertise?
For our first proposal that someone thinks it is too radical, the first proposal that proposed to the parliament, we propose to have all elected members, but the election system will not divide by provinces. Because we don't think that people in Ubon Ratchathani and in Songkhla should have different ideas of how to design this kind of system or electoral system or how to be prime minister. So we created a new system like a party list system, that all people who apply for this election will be in the same list, and people from anywhere in the country can vote for them to be the member of this constitutional drafting council. I don't know how to call it.
Assembly is council is fine, committee. Okay. So it's very difficult to come up with the supreme law of the land that everyone can kind of agree to. Let me move to Kun Angkana Nilapajit. Kun Angkana is she personifies Thailand's civil society. She's worked on human rights issues still does today, but she was a member of the National Human Rights Commission. And sometimes I think, in her time when you were at the Human Rights Commission, it was very active. And I think it was responsive, addressed a lot of issues that were needed to be addressed. And then to the point that I think it became a little bit controversial. The authorities did not like the Human Rights Commission at that time. But since then, Human Rights Commission in Thailand, very quiet. To the point that sometimes I look at the news flows and I think, do we still have the Human Rights Commission in Thailand? Kun Angkana, can you share with us why Human Rights Commission so passive and reactive now compared to the past? And what does that say about this, institutional design?
Thank you very much, Ajahn, and good morning, everyone. First of all, I want to remind you about the Human Rights Commission, the first commission that established under the Constitution 1999. In Thailand, after the political crackdown in 1992, under Prime Minister Anand Panjarachun regime, it's first time that the government ratified the International Convention on Civil and Political Rights. So at that year, the government also set up the drafting committee that selected from all the stakeholders in the country. And a lot of articles in the ICCPR were mentioned in our Constitution 1999. For example, the Article 14, access to justice of ICCPR, are in the Constitution 1999 also. And it's first time that the independence bodies were established under this Constitution. And for the Human Rights Commission, it's totally different. The independence body is totally different from other independence body because the Human Rights Commission have to follow the Paris Principle. The Paris Principle is the Paris Principle is the guideline for all the national human rights institutions, and it was adopted by the UN General Assembly in 1993. That the Paris Principle focus about the independent, impartial, and integrity that all human rights institutions should be. So that this is difference from other independent bodies. And in some countries, they have only ombudsman. In some countries, they have Human Rights Commission. But for Thailand, we have both. We have ombudsman and we have Human Rights Commission. But for ombudsman in Thailand, ombudsman will investigate only the violation from state actors. But Human Rights Commission will investigate both state and non-state violators. So this is one of the difference. And one thing I want to say is that I used to be involved in the Constitution Drafting Committee 2007. I'm one of the members of the Drafting Committee. I was nominated by Human Rights Commission, and then I was selected to be the drafting committee. During the drafting time, I can feel the emotion of anger of Prime Minister, the late Prime Minister Thaksin Shinawatra, after the war on drugs or other human rights violation at that time. I can feel the emotion of anger. The name of Thaksin was mentioned many times when we draft the Constitution. But anyway, Constitution 2007 have some article to make it easy for amendment. No, only maybe 10,000 people names can ask for amendment. But for 2017, the current one, I think it's very difficult, maybe most difficult among previous constitution, and difficult for amendment. So I think this is a problem. And for me, I think that we cannot write the constitution while we have the emotion of anger, or maybe we hate somebody and we put that emotion in our constitution. That the constitution have to to guarantee the rights of all people for a long time, so that I think during the drafting in 2017, the Human Rights Commission was invited by the drafting committee to sharing our about the Paris Principle, about the role and the mandate of Human Rights Commission, and I met Ajahn Jet during that time. I think that the committee not totally understand about international human rights law. I remind that at that time, some of the members, the constitution drafting members, mentioned about Thai culture, tradition, why for human rights institution, we have to follow the international human rights law, especially the Paris Principle. So this is some background of this Constitution 2017. And I think that for right now, I think the current Human Rights Commission, they face various problems and limitations from internal and external factors. The external factor is, for example, is the laws and regulations that make Human Rights Commission not independent. And for internal factors, it's about like the self-censorship of the commissioner, of some commissioner. And the drafting committee in the Constitution 2017 and Organic Law of Human Rights Commission Act said that the commissioner have to work together. So if you work together, it means that you need the consensus. So they have the majority and minority. When you are minority, you always lost. And for the minorities, for the majority, it's only group of majority that can decide what they want or what they do not want. So I think this is really challenges for the current commission. Ajahn J said that maybe the Thai people, the Thai society didn't heard about the what Human Rights Commission doing now. For myself, I can say that the current commission pay high attention on the economic, social, and cultural rights rather than civil and political rights. So when we talk about human rights, you should know that human rights are beyond law. And if any law and regulations that against the standard human rights, that law and regulation must be amended. So this is one thing I want to say. By the way, I would like to say that in the organic law and the Constitution, they have some progressive of Human Rights Commission. For example, in section 34, allow the Commission to examine the case of human rights violation, whether nobody complains. And in section 35, paragraph 2, is allow the Commission to enter any housing or place to examine fact or gather related evidence without permission, if that place is under the state agency. But if it is belong to non-state agency, the Commission have to ask for the search warrant. But unfortunately, we haven't seen the current Human Rights Commission apply this section to immediately investigate the cases of complaint of torture in military barracks in southern border provinces. By the way, the most concern of the one of the sections in the organic law is about the law in the section 44 of organic law and section 247, paragraph 4 of the Constitution 2017. It said that the Commission have to clarify and report without delay the true facts in the case of incorrect or unfair reports on the situation regarding to human rights in Thailand. This means that the Commission must investigate the human rights reports of civil society or the NGOs, and this might make the Commission to be used as a tool to protect the government rather than protection the rights of the rights holder, and this is also against the mandate of National Human Rights Institution regarding to Paris Principle. So it seems that Human Rights Commission Thailand have to be like the spokesperson to the government to clarify the report of the ILOs or other NGOs law. This is one thing that makes Human Rights Commission weak, and this is one thing that the country, the Global Alliance on Human Rights Institution is very concerned about Thailand. I would say that for Thailand, I really congratulate to the new, to the current commission that they got the status A since March this year. But it's also very challenges to the commission because the subcommittee on accreditation have the notes for the commission that the commission should work independently, impartially, and integrity. And also, the commission have to work closely with civil society. But the Human Rights Commission Act said that not allow the commission to set up the subcommittee. Actually, when we have the subcommittee, we invited a lot of NGOs or civil society or maybe the victims to be members of the subcommittee. And this is the inclusiveness that Human Rights Commission should be. But when the organic law said that we can set up the subcommittee only unavoidable reason. So the commission defined that this means the Human Rights Commission cannot set up any subcommittee. So it's very exclusion from the civil society. And this is one of the concerns that by the country or the National Human Rights Institution. I think this is very challenging as the National Human Rights Institution. I think Human Rights Commission Thailand has very crucial roles in promoting and protecting human rights, and they must work independently. They should support human rights defenders, women human rights defenders. They should act on behalf of the victims. They should protect the human rights defenders from judicial harassment. I think at least all the commissioner can do, at least they can observe the trial many of the young political activists were charged of serious crime. For example, the lèse majesté, the 116. At least the commissioner should sit in the courtroom to listen to the court hearing. I saw many of the diplomats sitting in the courtroom for trial observation. I often ask why the Human Rights Commission Thailand not doing that, so that they will understand what happened, what the role of the court. And the commission can ask for the meeting with the court and give recommendation. I think this is one thing that's very important that Human Rights Commission should do. I think if we stay as we are, afraid of our new generation, afraid of the futures, and in shortly, maybe nobody trusts Human Rights Commission. And I think that if people not trust all the independent bodies, maybe our country will have never-ending conflicts that cannot solve. I think the role and the mandate of the independent institution is very important. For example, the Anti-Corruption Commission, they have to follow the principle of the UN also. So how can they implement the international standard in our constitution and also in the organic law? And one last thing I want to point out is that after May 1992 crackdown, we have one of the good constitution, the Constitution 1999. I said one of the best because we have already 20 constitutions. And the 1999 make the political party very strong. And now political parties is very weak. So I think that if we want to establish the strong institution, we cannot avoid to amendment the constitution. And I think that we cannot write a good institution when we have conflict or we have like emotional of anger. So I think that's the best way is to welcome all the stakeholders to join the drafting committee. I know that ILO failed that already 2 times because, as I mentioned earlier, that Constitution 2017 makes it very, very difficult for amendment. I think everybody know why, because but we cannot use this Constitution forever without any changes.
Okay, thank you very much, Kun Angkana. I think you mentioned public trust. The trust in these agencies and institutions is critical. That we don't have enough trust. Also, for the Human Rights Commission as a case, it's really a telling example of how these institutions, these 6 institutions, have been captured by the ruling regime at a time when rights and freedoms are being violated, right, systematically. Human Rights Commission is more needed than ever. And when we think about human rights in Thailand or anywhere, I think we're not thinking about economic, social, cultural, right? I think we're thinking about civil, political rights. So it's a glaring omission and neglect by the Human Rights Commission. And certainly, when you mention trust, I think is a key word because we don't have trust in them anymore. I'll just give you another example. Recently there was a election commission member, right? So he resigned from the election commission, and then he just joined the Senate, just like that, right? So I think that even the authorities, they're not shy anymore about how they're in control of these institutions. Ajahn Jet, Dr. Jet, you've been involved with the constitution drafting. You are a law professor. First, do you think that, I mean, it's not in dispute anymore, right? That these institutions are politicized and not impartial, and maybe kind of functions, they are functions of the ruling regime. If that's the case, where did it go wrong, and how do we reset and reconstitute these institutional designs so it works to promote democratization and Thailand's democratic system?
Thank you, Ajahn Thitinan. And as always, I'm very pleased to be here speaking with all of you distinguished guests. Well, to answer Ajahn Thitinan's question, I think, yes, of course, it's unquestionable and it's indisputable that we need a reform to all these independent, whatever you call it, bodies, organizations, institutions. But it's a level of reform. What level of reform that you are willing to take on? Is it the level very minimal or at the maximum level? If it's at the maximum level, that's one issue. If it's at a minimal, that's another issue. Or if you want it to be moderately done, then that's also a different a different function. Okay, to be written into the constitution or to be had in the institutions. But actually, to me, the problem, if there's some or if there's many, started ever since the drafting of the 1997 Constitution. When they were drafting the 1997 Constitution, I was not in the country. I was out studying somewhere. And then when I returned to the country, that time they were distributing the small pocket book, the white cover. I couldn't remember whether or not that was the draft or it was the Constitution already. But they distributed that at the gas station. I went into one of the gas stations. They gave that booklet to me. Okay, I spent some minutes reading through very quickly, like skimming through. Then I had to spend some hours reading all of it because I was so worried about the Thai future after I saw that draft or that constitution. It was too radical at that time that it was written. It might have been thought of as an invention or an innovation. It might have been thought of as a people's constitution. It might have been looked at as a very unique and very promising constitution ever written, ever had in this country. But that was a very, very, very surprising to hear people talk about it so happily, because to me, that's the starting point of all what we have or all what we have had throughout the time ever since the 1997 Constitution. Why was it too radical? You put so much of what you thought were so innovative in there. In this country, most institutions, especially people who have positions in the institution, wanted to be the hegemon. They want to be number one. You make the 3 courts, that's the first wrong, because you should have had only the Supreme Court. You don't need the Constitutional Court. You don't need the Administrative Court. If you want administrative issues to be scrutinized or you want administrative issues to be done one way or another, then you have a branch of the Supreme Court to deal with that. If you want constitutional issues to be listened to or you want Constitution to be interpreted, then you need to have a branch in the Supreme Court to deal with constitutional issue, particularly. You look at the country like the United States. The United States is such a very big country. You have only 9 judges sitting in the Supreme Court. They are called the Supreme Court justice. You probably know the selection, how they select the justice. Okay, it's incomparable to what we have here in this country. But that very big country, if you have human rights issue, it goes to the Supreme Court. If you have anti-graft issue, it goes to the Supreme Court as the last resort. And you don't go to the Supreme Court that very easily. It's by writ of certiorari. If you wanted to go to the Supreme Court, you don't get to go to the Supreme Court. It's only when the Supreme Court see it that you should go to the Supreme Court. That's when you get to go to the Supreme Court. It's not by right that you go to the Supreme Court. It's legally selected that an issue will go to the Supreme Court, but that's the last resort, and the real last resort, the only resort. You don't make so many independent institutions. If you want to have all these institutions, then what you do with it is that you have to upgrade it. I think many of us here, the panelists, talk about it, that independence is not something that you write into the Constitution. It's not a name, it's not a label. When you label something independent, it doesn't come independent because you label it. There's no impartiality just because you write the word impartiality. There's nothing like that. There's no accountability because you said so in the law that there is accountability. They all come because of the function and how you work it out. So when you thought that election commission should be an independent body and then you make it independent, you can make someone administer the election and have it with the interior minister. But you might want to have a group of people who take control if there's something wrong. You might even have an election court to scrutinize, to investigate, instead of having an independent body that doesn't work. You don't need an anti-graft that is an independent body. It can stay with the government. But just how you select people to sit in that body, just like how you select judges, just like how every country in this whole world select their judges. A country cannot stand if you don't have a system in which you can select an impartial and accountable judge. Every country does have it to a certain extent. Be it a very, very bad country that you can think of in this world, they have a way in which a judge is selected independently by way of their function. You don't need an anti-graft to be such a way as independent body that we have. You don't need an ombudsman that stand alone. When we were drafting the Constitution during the time of the Bawansak draft, 2014, that draft failed the voting of the National Reform Council. In that draft, we were thinking of combining the Ombudsman and the Human Rights Commission and to make it the, whatever you want to call it, defender of the rights and liberties or the protector of the rights and liberties, so on and so forth. Because why? Because Kunakana said very clearly that the Human Rights Commission is dealing with state and non-state. The Ombudsman is dealing only with the state. Why do you need the Ombudsman to us at that time? We only need one body to oversee everything. And it doesn't have to be an independent body. But the two things that it needs to have, one thing Kunakana stated clear, observing position, Human Rights Commission or defender of the rights or ombudsman, whatever you call, needs to have an observing position to stay in courtrooms or to sit in some commission of the government as well as the commission of the parliament. That's what they need to have, the first thing. The second thing is to have the standing in court, that they can file lawsuit on behalf of the people who are violated. That's what they need to have. They don't have to be like very, very independent. And that is not against the Paris principles. You can make independency, you can make impartiality, you can make accountability, you can make so on and so forth, 7, 10, whatever principles, without having to have an independent body just as it is independent as you just wrote into it. And you don't need the Auditor General to be like so independent. They can work the way out that they worked hundreds of years before the country became so corrupted. The problem is corruption. It's not the way in which the organ was established or the organ was designed. So to me, you don't need independent bodies as such as to be independent. Of course, you need them to be independent. That's right. You need independency within them. You need accountability. You need impartiality. You need whatever words that you want to make it big. You need to have all those people who work within it to be with full integrity, honesty, and whatever you can think of, all these words. But you don't need them to be independent as such as you wrote into the Constitution of 1997. That's too radical to make a court, three courts, to make independence body, to make a Senate, to be fully elected in this country. And you said it will be good because they don't link to the member of parliament and the other group, which is the House of Representatives. There's no way that it will happen in this country. This is a country with very, very deep-rooted patronage. Okay? How can you get rid of nepotism? Really, really eliminate it in this country? No way. And you're talking about the Senate not be grouping with the House. No way. And so you make them fully elected, and then you combine them in a way in which you say it's non-political. And then you make the senators, all the elected senators, responsible for selecting the independent bodies. They are the same group of people. They work together. Whether there's a coup or not, whether there's an elected representative or not, they will be the same group of people to a certain extent. You don't always get a person like Kun Lankana. Sometimes you get them, but not always. And lastly, what I want to say is that the Constitutional Court is a court. It's not one of the 6 institutions that you call independent. It's a court. But people wrongly label the Constitutional Court as an independent body. It's not an independent body, it's a court. And I emphasize and I underline it 500 times that it's a court. Maybe it's ill-functioned. Maybe it's functionally incorrect by way of its own work. Therefore, it led people into thinking that it's a big brother, a big sister, a big sibling of the independent bodies. But it has never been designed, it's never been established as an independent institutions. It's a court. And people tend to talk about independent institution very much by way of talking about the Constitutional Court and how it's function, how it works, how it decides, how it so on and so forth. It's not an independent body. So I just period there.
Thank you very much, Dr. Jed. I think a very interesting point. So in your view, maybe the 1997 Constitution was too ambitious?
Yeah.
And
to me, I say it's too radical.
Yeah. Because I remember that we actually, in the mid-1990s, there were study teams looking at all the constitutions in the world to make the Thai constitution the best it could be. Hence, we had the ombudsman idea from the Scandinavian system, the party list idea from the German system. All this, it was designed to be eclectic, right? The best of the different
yes.
systems in the world. But in your view, maybe it became too ambitious and maybe too decentralized, because the court system, for example, I think the frustration at that time, the problem was that the Interior Ministry has so much power, and the bureaucracy has so much power, and therefore they wanted to decentralize, right? By setting up specialized bodies. Constitutional Court, all matters dealing with the Constitution. Administrative Court, all matters dealing with the conflicts between people and the bureaucracy and so on. So if that's the case, should we scrap the Constitutional Court? I mean, is it needed then? If it's just the design was too ambitious. Mm-hmm. And I think I like the point about, because, just because we write independent, it doesn't become independent.
Of course.
And just because we say it's independent, it doesn't become independent. It has to come through the track record, right? Yeah. And the trust.
You see, Ajahn Thitinan, some word, when it's written, it's hilarious, okay? For example, you write humanitarian war. What is a humanitarian war? Please tell me, what is a humanitarian war? There's no humanitarian war, but you write a word humanitarian war. Please make a humanitarian war. What kind of humanitarian war is it in this whole universe, not only in the world? So some of the writings just make fun of itself. So I was just thinking that maybe we've come too far. Okay, if I can, of course, I will go back to the time that we only have one court. Okay, one biggest court, Supreme Court, deal with all the issues. The independence body, I've already stated my case clear. And the electoral system, so on and so forth, I think we have to be realistic. Okay, and when we design electoral system, we don't design it because we want to make political parties strong, we want to make the government strong, we want to make that and this and this and that. We want to make a political will of people situated where it is appropriated to be situated. If it's to be situated in the parties, then it's in the parties. Okay, if it's situated in people, it's located somewhere. It has to be there. And if you design an electoral system, then you look at the country and what is it to be had in that country, and it will serve the country well. I think that's what it is. But we might have come too far to do what I said, okay, to eliminate all the independent organizations, to eliminate the constitutional court. What we might have to do is to be perhaps not so moderate reform, but not so ambitious, so radical, just as they did to the 1997 Constitution. But I think we have to rethink and make it scholastically thought of, which in the writing of our Constitution ever since 1932, there has never been an academic and scholar writings, at least to me. It's here and there. It's a negotiation between a group of people. It might be some compromise, but it's never been academically written. It has never been scholastically thought of. I think we need to sit down and think of what sort of constitutional court we want, what's the selection, and how will it work, keeping in mind that this is Thailand. This is not Germany. This is not Sweden, okay? This is not the United States. This is not United Kingdom. This is Thailand. You have to think of it too. Not that we're such a bad country, but how you get rid of some very deep-rooted graft that came with some of the issue that has been here hundreds of years.
Okay.
I think that's the design that I've always wanted. People sit down and talk, maybe like just like Ajahn Kem Tong, Kun Ying Chi was saying that we might need a group of people to sit down and discuss how we want to make our constitution work, how we want to make our independence body work, and all these things. And then set up a group of people, a group of experts to write for them. They don't write themselves, okay? If you elect people around the country, 100, 200, and you make these people write, they're not expert in the field. You have to have all these people who are the representative of the people around the country, who will talk to the people, who will bring from their hometown or wherever, or the group that they work for, the professional, the sort of occupations that they are within. Then they bring all those things, okay, bring the thinking, and then talk among themselves, and then set up a group of experts, make these group of experts write what they actually want, what they actually talk with the people. And then this will be a professional written document. And then this professionally written document will be submitted to that 100, 200 people, representative of the whole country. And this representative of the whole country go around the country, talk to people. Then the last round will be the referendum. And after that referendum, then you can say that's the people constitution. I think this is the design to me that I can think of now.
Okay, thank you very much. I think this is the kind of issues and discussions that will eventually take place again, because I think we will probably be either drafting a new constitution or having a major comprehensive overhaul of the existing constitution. And these are the issues that will inevitably come up. So it's good that you touch on them. I just want to bring up 2 points, and now the floor is open for questions and comments, also from the online audience members and also to the other speakers. Also, please feel free to interject and to make some remarks in reaction to what's been discussed. But Ajahn Chet, your first point about how much to reform, it's really, I think that's a crucial one, because, we're talking about the Thai constitution, and most people, I think, would agree that Thailand needs reform. Even the government and so on. It's just that how much. So this government, ultimately, I think we only have 2 amendments, right? One is on the 2-ballot system, and the other one is on the Political Parties Act.
Yeah.
but nothing else. So this is a very minor, although the two-ballot system is very important, but it's a cosmetic, very minor changes to the constitution.
Yeah.
So my question, I want to raise, to what extent Thailand, what kind of reforms and how far does it go? And we have to bring this up about the role of fundamental institutions in Thai society, the military, the role of the military regime now, the role of the monarchy in Thai constitution, in Thai politics. So I'm going to leave that, and you can talk a little bit about it, Ajahn, if you like. But I also want to mention about, the institutions that you mentioned. I mean, they're not independent, but at the time it was set up to promote some accountability, right? Because if you have Constitution Court, selected through the Senate, which is impartial and elected by people, at least there's people are in charge.
Yes.
As opposed to the bureaucracy,
Arguably,
the Interior Ministry, right? Okay, so
Well, just
Quick one.
touch upon that just a minute. I think it's very sad talking about reform. This coup that was staged talk about reform before election. Is long after election we're gonna have a new election. So that's sad. I think we need a big reform to this country, Ajahn Thininan, if I touch upon that quickly. And today we talk about the independent body. I don't think it's only the independent body that we need to reform. We need to actually reform democracy with the king as head of state. Whatever that is, we need to reform from the biggest to the smallest. Okay, so almost everything needs reform. It doesn't take like a week or a month or just a year. I think it takes longer than that. But we can do it little by little, and gradually it will be reformed.
Okay, Ajahn Kem Tong, may I bring you in? How far should we go? Where do we start in terms of a constitution?
Very far. But let me start with this. I'm very cautious approaching the talk about reform. I mean, starting with we talk about reform of these independent agencies, and actually there's many moving parts to start with. I mean, we can talk about nominate qualification of commissioners, but again, as I said earlier, but it goes to how we select the Senate and how we could strengthen the parliament as well. So actually, when you have to do a reform, it has to be an overall hauling. So you cannot just amend this and this part and think that things gonna get better, because there's still too many parts that gonna drag what you want to reform, drag your agenda down. So that's my first comment. How far? Now we come to, I mean, some observer of Thai politics describe our society as hyper-constitutionalism. So we keep wanting to draft a better constitution again and again. If anything is wrong happen, the first instinct is to draft a new constitution. Everyone agrees, like we're gonna draft it. Okay, so let me. So when the protests began in 2020 or 2020, there's 3 points of demand. And the first and foremost is the new constitution. The third and the last one is that police has to end their brutality against protesters and activists. I mean, looking back in hindsight, there's like, actually the last point is the one that's like very urgent, and that's something that very practical, and they didn't emphasize on that. So in the end, it's the police brutality that ruined the call for the first point of the new constitution. So we keep thinking about new constitution, a new legal constitution. We didn't really think about political constitution, which means the idea about transparency, the idea of right and liberties, the idea of I mean, all the democratic liberal values that we're supposed to think about before we draft the law. So that's something that we have to keep in mind. But what is the Constitution anyway? I mean, we can write anything we want, right? And it become meaningless. I don't think it is so. A Constitution is not what describes us as what we are, who we are. I mean, it is not about what is. I mean, oftentimes a Constitution is about what ought, who we want to be, who we aspire to be. So we may not get there. We may not be an independent body. We may not have a truly independent body. But if you never write it down, you don't have that benchmark, you don't have that goal, and you will never get an independent body, right? I mean, if you write it down, you may or may not reach there. If you don't write it down, there's a blank check for the commissioner to do whatever they want to do. So that's my third point. Thank you very much.
Okay, the floor is open for questions, comments. Could we, Ajahn Kem Tong and Kun Ying Chip, I mean, the constitution we have now to 2017 is conveniently every 10 years is one. So 1997, 2007, 2017, and each one. So from 97 to 2007, the Senate became more appointed. The rules were tweaked and adjusted to get a certain outcome, but they didn't get it. So the 2017 one is a very severe one. It's a very strong one, which means it's a long-term control by military-backed regime. If we go back, is the 1997 Constitution there's a good starting point? I mean, if the Constitution is scrapped today, where do we start?
I am surprised to hear that Ajahn Jet was surprised for the 1997. I was too young at that time. Regarding Ajahn Thithinan's question, is it a good starting point? I think yes. It is not perfect. I don't totally agree with the 1997 Constitution, and I also don't totally agree to have 3 courts, like Ajahn Jet said. Maybe we can have one, but when the 1997 Constitution starts to play its role reforming the country, and we disagree with some part, we can change or we can amend some part later. We have experienced the first and second elected senators, which not very different from the elected MPs. But we can amending the 1997 Constitution from that experience and keep going, not just going backwards. When we are talking about reform, Ajahn Thithinan asks how radical should we reform, how progressive should we go. I think as of today, our demand is just asking to be something normal. When we discussing about something normal in the area of normal, people should have their right to vote for their prime minister, not the senators. The check and balance body should be independent, should come from independent process. These are normal areas. We just trying to bring things back to normal area from the current structure that is not normal. We are not talking about something too progressive or too radical. If the proposal to have only single parliament without Senate at all, I admit that this is progressive, or someone think it is radical, but that's not necessary. But the very urgent necessary from now is just to bring things back to normal, to stop the selected senators to vote for General Prayut again, or to stop these people in the expected independent institutions from exercising their power, supporting the current government, and to get rid of only the opposition parties. That's it.
Let me focus on the role of the Senate, since you brought it up, and I think it's a good time to look at the Senate a little bit. Before the 1997 Constitution, we had the Senate for most of Thai politics since 1932. But the Senate was always appointed, right, until 1997 Constitution. But it didn't have that much power, right? It didn't have lawmaking power. But the Senate since then, 1997, has a lot more power. And now the Senate today has enormous decisive power in many ways. So, for example, the next election, I like your diagram, Kun Yingchip, because the Senate, the same Senate that enable this government to take power, take office, is going to still be around in the next election to presumably back a kind of a similar regime again. And that might be enough to have the similar outcome, That might be enough, because if the Senate gets to choose Prime Minister and Parliament, that's already one-third. That's already one-third of Parliament. So do we need a Senate? I mean, it's been appointed, and when it's elected, now it's appointed again, and now I think the Senate now is more regime, as a kind of a regime-backed body than ever, right? Than we've seen in Thai politics. So maybe, Ajahn Kem Tong, maybe just a single parliamentary body, constitution assembly without the Senate.
Ajahn Thitinan, we don't go that far, and we don't design things out of just a one problem and a one time of the problem. If we think that these senators, all these people who were handpicked, or whatever you want to say, you want to call it, from a one person, which is General Pawit, that we know of, we don't know whether there's a group of people who were the selection committee. And then we think that from now on, this country should be unicameral. No more bicameral. Just because of all these senators, I think we are doing that very shortcoming, okay? Especially when I was saying that we have never had any academic and scholar constitution drafting panel. Okay, I've been in many of the panels, and then I say that myself. So I think we have to really, really think. And when I said I was worried about the 1997 Constitution, because this is Thailand, okay? You say you probably young that time, you're not young this time, okay? Thinking of that, this is Thailand, and thinking back to the 1997 Constitution, this is Thailand, okay? You said, of course, you want to write, Ajahn Kem Tong said, you have to write independent, so they will have some rule, they have some Bible to walk. Well, whatever you say, okay? But thinking back to the 1997 Constitution, that time that I saw, I worried. And everything that I worried that day became all true and more to this day. Yes, of course, you don't need the senators to have this crazy function. Okay? There's only about a 1.2 million voters who came to the referendum that realized that this will be a crazy function, because those who passed the Constitution through the referendum outnumber those who passed the question about whether or not the Senate should be voting, just 1.2 million. So those 1.2 million people realize that yes, it's okay to have that constitution, but it's not okay to have this sort of senators. But the rest, what happened to the rest? And that's what the NCPO, the former NCPO said, because the people voted for us. I think that's wrong, that's bad, and that's deceptive. But if you can have a decepting referendum, you can of course have a deceiving election also. So we have to also think of this. It's structurally wrong, yes, but isn't the country also structurally wrong? So which one should we do first? Write a good constitution first, or do away with the problems of this country first? Educate the people. Try to empower them. enhance the situation? Which can be first? I don't know. But I'm just raising this question. Which should be first? The writing or the action?
Go ahead.
Thank you. So in the realm of comparative constitutional law, every design that you question is possible. There's country with bicameral structure as we do have, and there's unicameral, fully democratic, fully functioning democracy country that in the world to unicameral. I think New Zealand is one.
And unicameral, Thailand has had before. So
Yes,
it's not unprecedented.
It works. So in the realm of comparative constitutional law, a lot of things, many designs, different designs possible. And when we think of applying it to Thailand, we think of all the context and transplant. And I think of Rand Herschel, professor of comparative law in Toronto. You are unique, so is everyone else. So of course, I mean, every country tend to think that we are unique in some way. UK is unique. We don't have written constitution. Thailand is unique. India is unique. But in the end, I mean, we are unique all the same. So everything is possible. So when it comes to the question of unicameralism in Thailand, I mean, scholar opinion is one thing. We should or we should have. But of course, I mean, there's popular opinion as well when drafting, I mean, the real drafting come into play, that they want it or not. I mean, we might not draft something scholarly perfect, but if the people are happy, maybe you have to consider that. And I think the call for unicameralism is growing stronger. Having an elected Senate might be another solution if you still want to have a bicameral structure. Having an elected Senate, as in 1997, might be an answer. And actually, that's the only thing that legitimizes the independent agencies, because that's the last act of delegation, approval by the Senate, and the Senate was fully elected. So that's the only time that the people indirectly delegate their power to independent agencies. So you don't see that in 2007, you don't see that in 2017, because these senates are not fully elected. So they are not delegated by the people at all. I think it has very significant symbolism that you know that you are appointed or approved by representative of the people. And when you are aware that you are actually appointed by friends and cronies of the junta. So I think there's only two ways, either unicameralism or fully elected Senate. Thank you.
Okay. In the last bit of time that we have, I want to just return a bit to look ahead in Thai politics in view of our discussion. So you can see that we have election within a year. Right. So by this time next year, if not by June 2023, it will be a little bit earlier, we'll have a new government. And the way that the system is now set up, the role of the Constitutional Court, the role of the Election Commission, the Anti-Corruption Commission will be critical, will be very important, crucial, and perhaps even decisive. It is possible that we will see more party dissolutions. And the role of the Election Commission will be crucial in determining who gets banned or who gets into parliament and so on. So are we looking at now, since the institutions are captured in this way or set up now in this way after the coup in 2014, the election outcome next year in view of our discussion, probably same in 2019? Certainly, I'll just come to Kunangana first. Rights and freedoms, would you say that now they're more violated systematically or less than before or more than before in your time as Human Rights Commissioner?
I think that right now, we are in divided society, so that the group of people who support the government will be like more comfortable than in others. When we're looking at the young generation, maybe we are, fortunately we have children, no? So that we understand about the new generation, what they think about, what they design for their futures. But sometimes when they think different of the government, they will be easily attacked. And I understand that we cannot write any constitution that everyone agreed or happy with that. But one thing I want to say is that the constitution must welcome all the voices of the people. Not only the majority is the winner and the minority always the loss. Ajahn Jet mentioned about the empowerment of the people. Honestly, I work a lot with the people on the ground. I would like to say that every time I talk to the local people, I'm really humble to them. Many of them have much knowledge than me. They have a life experience. They have, maybe they're not got the bachelor or the doctor, but their life experience is very benefit to the country. So I think that when we want to create the society that was trusted by all people, that welcome all people together, I think we have to like amendment of the constitution, because we cannot avoid saying that constitution is not only thing, but we have to do others also. I agree with Ajahn Jet, no, that for the court, for myself, I respect the court, but many times I'm not agree, honestly. And it's my right to agree or not agree with the court. But you know that it's a constitution that decides about the Court of Justice, the Administrative Court, the Supreme Court, the Constitutional Court. If we look at the 1997 Constitution, it decided about the Court Commission that have like the representative from the Supreme Court, Appeal Court, and primary court. The number, the ratio is similar, maybe 4-4-4. But in the Constitution 2007, majority goes through the Supreme Court and Appeal Court. And the new generation of the judges are only few. In 2017 Constitution, it's not mentioned about the number, but it refers to the organic law of the court. So who wrote it will be on that benefit. And is that only small group of people that can decide it? And you know that when I'm the commissioner, I was selected by the selection committee that all are judges. And 7 of the candidates, when our name was sent to the National Legislative Assembly, all are adopted by the NRA. Maybe because they trust the judge, they trust the selection committee. But when the Human Rights Commission changes the selection committee to include the civil society, so now when the candidates was sent to the Senate for consideration, many times that is failed. Some candidates got only less than 10 score amongst 200 plus of the senator. How it happened? Is maybe that person have no value anymore. So that I think that the senator not trust the committee that have engagement with the civil society. This is a very important point that I would like to say, so that I think that if we want to have the reconciliation society, people can live peacefully together. I think that all voices must be heard, and we should make the constitution to have the inclusive, that welcome everybody, not that for the minorities, whatever they said, they will be the wrongdoer. Many of the new generation now in jail because they only exercise their freedom of expression. I think we should respect, no? Everybody can have their own dreams, can have whatever they want to, with non-violence means. It's only the speech, no? The right to speak. But if they didn't do anything, any crimes, or they didn't use any all kind of violence, they should not put in jail. I think this is one thing that we should come together with all stakeholders and try to amendment like the important laws and constitution that.
Thank you very much, Kun Kana. There's some comments online that there's a lack of popular legitimacy. These institutions are so much affected or determined by the appointed Senate. This has resulted in a lack of popular legitimacy because it doesn't show that people really own the country, a lack of popular will reflected in these institutions. I'll just come around the very last 1 minute. If the institutions that we're talking about, we don't have to say independent or whatever, but such as they are now, we've seen them in operation over the last several years. So if you look ahead a little bit, within the next 1 year, we'll have election and new government. So can we expect more of the same, this kind of ruling regime perpetuating its power after election because of the institutions, Constitutional Court, Election Commission, Anti-Corruption Commission? I'll just come quickly, Ajahn Jet, and then Kun Ying Cheep and Ajahn Kem Tong, you can have the last word. Looking ahead a little bit.
Well, in short, if you say 1 year, nothing will change. Okay, my hazard guess for the country is that we have a high tendency, and it's very likely that there will be another coup down the road. So I just say that.
Okay, sounds like we have to start over again with another public forum because Ajahn Jet thinks that there will be another coup. All right. Well, we've had. Let me a little bit maybe explore that comment. It is. I'm not sure if this is your line of thinking, but there's going to be a lot of tension because there will be election, and the current government is not expected to do very well. Mm-hmm. Yes. The opposition parties are expected to do well, maybe better than last time, maybe well enough to take over government. If that is the case, I don't know if that's what you're thinking. Yeah. If that is the case, and if the goal is to maintain and keep power, it has to be done by other means.
Yeah. Let's say this, I link it quickly. When you ask me what happened in the 1 year time from here, all the independent bodies, including the Constitutional Court, remains the same for me. The senators remain the same. What will likely happen is that, let's say Pheu Thai win, perhaps not like landslide, but win the majority or get the highest number, and then is able to group with Cao Klai or whatever parties to form the majority in the government. Then the minority group together with the Senate to select General Prayut or whoever at that time. Then people come out demonstrating, protesting, okay, rallying, and whatever it can be had, okay? Then the military come out again. And then they use the old same issue the country is in chaos. We need peace. Then they take over the country. That's why I was saying that we are likely to have another coup.
Yeah, okay. Thank you very much. If that is the case, it will be a military takeover in a new era, and it will be something that will be new in Thai politics in that way. Coup is not new, but new era is new. Or maybe Kun Ying Sheep, Ajahn Kem Tong, maybe there will be a judicial intervention equivalent to a military coup. Could that to determine the outcome, right? And so, just very quickly, your outlook ahead. And we talk about these institutions. We know now what they're about, and how. And we don't know. We don't have an agreement about what to do, but we have an agreement about the need for reform. But looking ahead, since they're still like this without reform, what's your outlook? Election within a year's time.
Looking at the current constitutional court rulings, like on the marriage equality, on some matters, I think the court also hesitate to overturn the system or something. They just hesitate, but doesn't mean they will not do. In the future, I sadly to say that I kind of think like Ajahn Jet, that it is likely that the next coup is possible, but I will be disagree with the coup, whatever reasons they will claim. But sorry, Ajahn Titan, I think I saw some hands in the room. Should we open for
I'm sorry.
participation? Yeah.
Oh yeah, okay. Two hands. I'm very sorry. We'll just take a couple minutes extra. Please feel free to post your question or comment. Or
thank you very much. My name is Subel. I'm with Radio Free Asia. My question is about to Dr. Jade. You talked about the structural issue earlier, briefly touched on it. What is the role of monarchy in 2017 Constitution, and what should it be in your opinion? Second question is, we have talked a lot about the Senate in 2017 election, Constitution especially. Has Senate hijacked the political system in Thailand at this point? And how do you see it forward next election? And because all the panelists are constitutional experts, just briefly on Prayut's 8-year not ending in August, it's a little bit tricky to understand what's going on there.
Okay.
Thank you.
Okay, thank you very much. So the role of monarchy, role of Senate, whether the Senate has hijacked the political system, and General Prayut's 8-year mark, when do we start counting the 8 years? Is there any more hand up? Yeah, Ambassador James Wise.
Thank you for a very useful discussion and in so many ways illuminating. The protection of the independence of the judiciary or independent institutions is important in countries like Australia, where I'm from, but in other countries which have some experiences like Thailand too. And it seems to me, certainly in Australia and in Malaysia, which is the other country I know quite well, the strongest advocates for the independence of the judiciary, and the advocates that speak first, tend to be lawyers themselves and their professional bodies. In Malaysia, for example, every few months, the Bar Council of Malaysia would organise discussions on these sorts of issues. Unless I'm mistaken, Thailand doesn't have a similar body. The lawyers of Thailand are not on the front foot, if you like, to use a cricketing term, in protecting the independence of the judiciary, or out there fighting for the establishment of true independence of the judiciary. Am I right in that conclusion? If so, why is it that Thailand differs in this regard? Okay,
that's a very good point, very perceptive. Who's fighting for judicial integrity, right? Integrity and impartiality. In other countries, the lawyers, the legal profession would have a vested interest in having a independent, impartial judiciary. So look, we're a little bit over time. I'm just going to take a quick round across, and then I think some of the answers are implicit in this discussion already. The role of the Senate is very dominant, so of course influential, decisive in the political system. We already saw that. Monarchy, we touched on a little bit. General Prayut's term, 8 years, I mean, implicit in this discussion, the Constitutional Court most likely will not rule the 8 years to be this August, right? If you look at the past examples of their decisions. And then why the lawyers are not fighting for we have law professors, why are not lawyers fighting for more judicial independence, impartiality? I'll just, a quick, if I may, we're over time. There's a minute from you, Ajahn Jed, and then Ajahn Kim Tong.
Yeah. The role of monarchy constitutionally remains the same. There might be something in practice that's different from our late king. That's because it's a different realm. So there's many things differently done. Okay, that is what in the practical function. Okay, not in the constitutional function. So the constitutional function of the monarchy remains the same. There's never been any restructuring or there's never been any reform to that. Okay, to me, General Prayut's term must end this August. Okay, but I agree with Ajahn Thitinan that respectfully, the Constitutional Court might rule differently. Okay, why are lawyers not fighting for each other here in this country, or why are they not protecting the judiciary? I don't really know, but we have the society. Okay, we have the organization, the same as what you raised as in example in Australia, in Malaysia. Okay, but that might be strongly practiced in something else, not this role that you mentioned.
Thank you very much. Ajahn Kim Tong, questions have to do with the legal profession and the law.
Okay, so looking ahead for another year, I think there's all these independent agencies help control and dominate Thai politics already. I mean, there's very little chance of any radical, abrupt change in this direction. For example, last week, the Election Commission just acquit the Move Forward party from overthrowing the democratic regime with the king as the head of the state. What did Move Forward do? Move Forward tried to propose an amendment to the 112 Lèse Majesté law, and someone complained that they were trying to overthrow the king. The EC acquitted Move Forward because the EC said that it's just an act in preparation. The amendment bill hasn't been proposed to the parliament yet. So yes, the EC acquit the party, but at the same time, it ruled that once you dare to propose the bill and the bill reach the parliament, we will dissolve you. So under this kind of situation, with this mentality of these independent agencies, you can see that there's actually no need for a coup, because politics will be dominated by all these elites, conservative. So that's part of it. To answer the question of and why Thai Bar Association never fight for freedom and right and liberties and independence for what? I mean, back to my first presentation, independent for what and from what also? I mean, from how to say, mundane or vernacular criticisms from the commoners and to serve the state. It seems like Thai judiciary is oriented that way. So when the state and the people is not one and the same thing, to be loyal and working for and to serve the state is very different from serving the people, and that's what Thai judicial independence means. Thank you very much.
Thank you very much. And on the judicial independence and impartiality, I'll just add that if there's lack of public trust in the judiciary, this is a very worrying trend in Thai society. Look, I think today, we have no conclusion about what to do with the constitutional design, institutional design within the constitution, how far to go. But I think we do agree that these institutions are not serving Thailand's democratic system well, and they need to be reformed. And I'm sure that we will come back to these issues again. Please join me in thanking the speakers, and also thank you very much for coming. Thank you.